hope I haven't added too much to it.
Seems to be, if anything,
Even hotter.
right.
I mentioned the case of Pierce. I
Yes.
have got copies.
So you,
I'll just give you the paragraph references.
sorry? Well, he's not. Can I try it?
There's 3 copies of each.
Yeah, it's all right.
There's
He's
2
not
judgments 3 times.
making a run for it. We're going to try opening the door again if there's a lot of noise from the corridor.
Just to give you the paragraph references in Supreme Court case, which is about fact finding in a risk assessment context. It's paragraph 62 to 65. Mr. Armstrong has also handed up a recent case of De Silva, judgment of Mrs. Justice Hill, which I've just had a look at. Discusses Pierce and Orgas and how that all applies in a risk assessment context. I'm not going to make any submissions about either judgment. All I would say is it was no part of the pleaded case below and is no part of this appeal that the management committee misdirected itself in law or misunderstood its role in the way in which it took factual matters into account. That was an issue in the cases in the reports before you, but is not an issue. Well, it certainly was an issue in De Silva, not an issue before you.
I don't think I've got a copy of it here.
Yeah.
Which paragraphs did you say were relevant to Pierce?
64 to, well,
62 to 65.
62 to 65.
Okay.
I've handed that up. I'll deal with it in a moment.
Yeah, so I'm not going to make any submissions. Again, my main point is it's not a ground of challenge below and not a ground of appeal here that there was a misdirection or a misunderstanding by the committee about how it was to go about its risk assessment function in terms of finding fact or not finding facts. And indeed, sorry, I won't go any further.
Were a transcript, which there isn't, you could say, and indeed, dash, brackets, council sat down suddenly. Right, Mr. Armstrong.
Thank you. My lords, my lady, I've got now 56 minutes. I think I can do it. Can I just deal firstly with some response to queries yesterday, which I said I would deal with overnight. So I do need to take a little time to deal with that. Can I just, 1 or 2 of these are corrections of things where I don't know the answer as well. Can I remind you, I think you know this, as well as the monthly CSC MCs, which are informed by local MDT reports, you have the CMG that sits monthly, you have the quarterly CMP, which is the local, and also an annual MDT review. The point I'm raising here is that my solicitor, who now sits behind me, and does not attend either the CSC MC or the CMG, he is occasionally at the local CMP.
Yeah.
So you know that. With regard to Mr. Thakrar himself, the evidence is in Mr. Worsman's witness statement of paragraph 31. There are variations of practice between prisons about how this is done and indeed how long you get with individual allegations or things that are in the reports before you go in. But you get the document, you then make reps, then you at some point later, and how much later and how it's done varies, the recommendation and the decision, so you know that. So sometimes when you see references to, there's 1 or 2 references to Mr. Thakrar walking out of a review, it's quite often when he's pulled in, given the document, he disagrees with something and leaves at that stage. That is what that is a reference to. It's the MDT process, the precursor to the CSC MC decision, not in the CSC MC itself.
So typically, you're given the monthly review document.
He goes to a room
in advance.
Well, or he's taken into a room and he's given it as he goes in, is my understanding.
All right. You make representations in Mr. Thakrar's case because he's articulate and good at writing things down. Sometimes he writes a response, sometimes he annotates the review, and then you generally attend.
Well, That process is usually conducted, as I understand it, that process is usually conducted. He's taken to a room and said, "Here are the documents."
Yes.
What do you want? Or he puts in written reps, and then then that stops from his point of view, and he gets the
Oh, I
recommendation.
see, yes.
He gets the recommendation and the decision thereafter.
Or his solicitor, sometimes we see reference to his solicitors.
Yes,
To representations from his solicitor, so
Yes, that can be done.
sometimes the solicitor gets provided with the report and
Yes.
stuff as well, I believe.
only from him.
Or they,
Yeah.
he's shaking his head no. But anyway, at some point the solicitors get them, whether they're given them by Mr. Thakrar or sent by the prison. Either way, they get them, and on some occasions we've seen that they've put in written representations.
Yes.
The solicitor has, and those are sent to the CSCMC.
Yes, I think that's right.
Okay.
So you don't attend as if you were attending a hearing, but
Or the meeting, yes.
you're given the report and you may be asked, is anything you'd like
Yes, exactly.
to be taken?
He's not part of a discussion with, Mr. Worsman or Mr. Petz or
Yeah.
something like that. My lady, you asked a question about personal trainer. He doesn't have a personal trainer because he's not at the gym, and the reference to that is there are some suggestions that but they're disputed. The undisputed evidence is Mr. Thackrar's witness statement at page 26 of the supplementary bundle and page 42, which he has not been to the gym in the 2-year period with which we are concerned. The references to exercise are him walking around the yard on his own. The move to Whitemore you asked as well, my lady. We have correspondence about that. It wasn't the first correspondence, but it's later in 2024. It is said, so far as we know, that another prisoner raised a concern about him and another person. That allegation has obviously not been tested or anything of that kind, and he moved as a result of that. That's what we understand. There was an allegation, and he moved as a result, and obviously all of
Moved
that.
from Manchester as a result of that.
Yes. The letter I have handed up, I'm reluctant to put in evidence at this stage, but because my Lord Justice Baker answered it, I asked the question yesterday. It was sent, this is Dr. Crassiati's report was served in July 22, and we got that letter, back, which you now have, which is the 8th of August letter, saying that it will be taken into account. I'll make some submissions in a moment about whether it was in fact taken into account in any meaningful way. I'll deal with that later. My Lord Justice Baker also yesterday asked me a question about whether he would agree to a joint expert. The answer to that, just on instructions, is absolutely he would. He would say that he says that he has done, this isn't an evidence, but he says yes he would and he has done before. His difficulty is he doesn't like a process where he is not part of the information flow to the experts because he doesn't trust the process. And he also is concerned about processes in which he's not involved that lead to outcomes he doesn't like, or being used for a purpose that he does not think should be used. So, for example, the transfer or sectioning, which has been discussed from time to time. I'm not inviting you to reach conclusions about any of that, of course, but that's what his concern is, and that's part of his response to why he wants information done in that way. And of course, if you had a normal joint expert, both sides would ask questions. That's where he's perfectly content with that. If you'd had joint instructed expert, and he would.
Well, we have insofar as this is relevant, we have to go by what the documents show.
Absolutely, but it's just I took instructions.
Yeah.
We understand that Dr. Crassiati has retired. I think you asked a question about this. Somebody asked a question about this yesterday.
I wonder when she retired from the NHS.
Sorry. Yeah. She's in retirement, to my understanding. And the final point, just on corrections or clarifications, the answer to the question about whether the April 21 phone call in which he is said to have threatened a probation officer is disputed, and the reference is in his witness statement at page 17 of the supplementary bundle, paragraph 11. I'm going to make, partly in line with the exchange that you had with my learned friend about factual matters, he has not had the opportunity to explore, investigate that via an adjudication or anything else. That is significant, we say. He has said that in his evidence. One of the things that he says, and this is in the statement, is that he has asked for and not received the recording of the phone call in which he is said to have had it. So anything that you want to say about whether it is in fact said or context or anything else is lost to him. That is also true, incidentally, of another allegation that's made about stuff that is recorded on body-worn camera footage. He hasn't had the body-worn camera footage either. So those are matters that, if these were properly investigated and explored, he would go, well, show me the evidence on which you rely and I'll see what I can say about it. But he does not have those things. But that's the reference in relation to the April 21 call. Now, move.
To a probation officer, but that is because offender managers are probation officers.
Yes, I mean, they're now called prison offender managers, so it's an internal probation involved in sentence planning and so on. Can I just, by way of opening my reply, I know I don't need to, but remind you of the seriousness of this, remind you of what it means for him. There is unchallenged evidence about the impact. It's not disputed. I read to you yesterday the including part of his witness statement, what he says about the impact on him. You've seen shades of it in Dr. Crassiati's evidence, and it is in any event well anticipated and understood that even short-term segregation produces harm, long-term segregation produces serious harm. You are doing this on top of a personality and a mental health presentation that is already in difficulty, hence the offending. So you see that all and see all the references in Borgas. It's set out at some length in Borgas. Anybody would struggle with segregation. People who have the personalities and the difficulties that the prison population tend to have suffer all the more. So that is what we're looking at, and we're looking at very long-term segregation in an already very deprived environment. How is it justified? I'm afraid you're going to hear this from me again in the way that you've heard it from Mr. Gradinsky. We have to look very closely at the documents. We have to look at the operative parts of those documents where the reasoning of the CSCMC is recorded, and the things that they say that they took into account, not the things that not the things that the psychologists or unit staff say in the run-up to it, but what they, the decision maker, decide is relevant. That is the thing that he needs to address. But I'll come back to what some of the run-up to it means and doesn't mean in a moment. We have had problems with the documents, you know. I'm not suggesting that the fact that we actually don't seem to have the May and June 21 documents, I'm not suggesting much turns on that. That's because we're relatively early in the process, and obviously I'm much more concerned with the justification for this as time goes on, so I want more reasons later than I do at the beginning. Can I, however, my learned friend handed up the two documents that were missing from the bundle, September and October 21. He took you to September. He didn't take you to October. Can I just point out that the October 21 justification for this treatment, which you can then go...
You need to give us the reference.
I don't know what page it is because it was added in loose. I don't know where page number is, but it went in...
After 196.
After 196.
I got as far as putting 196A on the first
So
page.
it'll be whatever the last page of the edition is.
So
G.
G.
Well, G is the very last page. CM.
It's got the incorrect page number is 612. If that helps you at all.
The correct.
Well, it's the incorrect because it's taken
The
from the front
incorrect.
below, but it happens to be the
G is his handwritten.
Yes.
The last of the second.
Yes, yeah, the second of the second. Yeah. Just to remind you, and I am going to say, I'm afraid this is woefully inadequate for the exit. When you look at what happens in Awali, when you look at what they required in Borgas, what they say is required in the analogous segregation context in the policy that followed Borgas, what this says is there is no recommendation as to what the CSCMC is being asked to rely on. That is blank. And then the feedback, so the decision is the CMP has taken place. He is engaging and doing well at the moment. He doesn't like the heat in his cell, and he does complain about this, but he's polite and he's engaging with the regime, settled and no issues raised at that time. How does that get close to explaining to anybody or showing that the decision maker has engaged with the reasons why this, and what's going to become much longer, already 6 month segregation within the CSC is justified?
Do you accept that the feedback given the previous month on, so I'm assuming is the 569 was met the required standard?
No, because it doesn't get into the substance. The how is the fact it's said there? You know, he says he wasn't using it. You'll see that he says it's disputed in the corner. But how doesn't matter. How is the fact that he is, even if true, he's making use of the gym and the astroturf? How is that part of the justification for segregation? How is the fact that he has raised, and I mean, my learned friend has done this several times, he has taken you through these documents saying he knows what the reasons for the decision are. Look at what he's writing on the side of the document, it said. This says, Mr. Thakrar voiced concerns this month that Full Sutton were not sending his representations to the CSCMC. He says that's not true. But how is that relevant to a decision to segregate? Mr. Worsman clarified that he didn't state the CMG review, so something that Mr. Worsman disputes factual matter about something he said to have. How is that relevant? Then, Mr. Thackrar's location at HMP Belmarsh was facilitated following a request from his solicitor for an impending court case. He says false because you remember that stated. That's not quite what happened. The committee recommend that Mr. Thakrar continues to build appropriate relationships with the local team and engage in his CMP to help plot an appropriate pathway from Belmarsh. That's not even beginning to engage with impact, whether there are any allegations, what the behaviour relied upon is. Are you still talking about, is he here for court proceedings? This is, again, you are doing something serious. You are doing something that may undermine everything you are trying to achieve with this man. You are potentially harming him, potentially permanently. This is an absolute classic exemplar of a high-level, intense institutionalisation of somebody who is maybe made worse by this process, and you don't deal with it at all.
And he'd have seen the rest of this document, wouldn't he?
Yes, he has. I assume so. And I would accept, but I don't think they do this, they may do it from time to time, if you had a document that said, if you had the operative bit of the decision from the CSCMC said, for the reasons set out by the psychologist, we think that this is justifiable, then that would be a different matter, but you don't have that. What we want to look at, what he needs to understand, is why the people who are actually making the decisions that govern his life think. And then, when he knows what they think, he can address them on it, but he's not being told that. That is why the paucity of these documents is why my learned friend is having to cast around in other documents, including the minutes, including the nominals, including Mr. Worsman's evidence, to say this is what the reasons were, or letters of dissent to him. I invite you to read all of those very carefully, but subject to all the caveats that I made yesterday, which is ex post facto justification.
The minutes reflect the decisions, don't they?
They're not the communicated reasons. He doesn't see them. So
Well, there are two separate points, aren't there?
there are.
There's ground 4, what were their true reasons, and ground 5, what reasons did they communicate?
Absolutely true.
Yeah.
But I accept the minutes are relevant to, I think it's ground 4, which is, did you actually do this? Did you think about it at all? Come back to that. They are not relevant to the reasons ground, which I think is ground 5.
No, we look pretty well exclusively at
Exactly.
the letters to him, well, really what he was given each month, and then supplemented by, I think there were a couple of letters.
There's a couple of letters, but they don't say much either. And I am
Six letters were there.
We were showing examples
Over 2 years.
of where the feedback given to him reflected word for word.
that's different. When that happens, fine.
Okay.
I see that.
Is your case really that should happen every time?
Well, it depends what it can do. Well, no, my case is that they should think about what they're doing, think about the impact, think about it whether justified, thinking about whether you can continue to justify it, and we need to see your thinking. I mean, if you've got that in your reasoning, great, but they don't. I mean, where it then comes from, but if they've got all of that reasoning in the minutes, but it's not in the decision that's communicated to him, they would have a problem. But we're not even in that territory, because I say the reasons are never good enough. And I don't want to jump ahead of myself too much, but my learned friend is driven to say, you can imply this, you can infer that this has been considered, because there is a passing reference. They know he's in a DC. They're having a meeting. They're having a meeting about somebody in Belmarsh, and the only way you can be a CSC prisoner in Belmarsh is in DC. And you can say, so when they say suitably located, they must mean both. And that's the case that he advances. Not enough. Not enough. And I'll come back to
Even
this.
when he's in Belmarsh, they think at his own request.
Yeah, well, they're wrong about But I mean, and they're certainly wrong about that after it gets past January 22. But no, it's not enough. And the reason why it's not enough is they have to think about the impact. They have to go, rather than just doing this, he's all bringing it all down upon himself. I mean, I will say, even if he is bringing it all down upon himself, I say he's got some reasons for what he's doing, and they are protected reasons because he knows his own mental health and presentation and is entitled to be protective of that. But even if you rejected all of that and went, you're just being bonkers, you're just being self-destructive, Mr. Thakrar, why do you keep doing it? It's all bring it down, which is what Secretary does say. You still can't do it forever. And or if you're going to do it for these periods of time, you need to think about what you're doing. In particular, impact on him. Are you making him irretrievably unwell? Are you giving him a personality disorder? Are you just making him more suspicious? Ruminate more perception of injustice. And just while I'm on perception of injustice, you already know that he has that presentation. If you are going to repeatedly rely on allegations that you don't substantiate, don't run to an adjudication, etc., he is going to feel, and does, feel more unjust, more badly done to about that. Of course he will. You're relying on this document, you're relying on this allegation. Where do I get the chance to deal with it? I will come back to that, in particular by reference to the psychology allegation, that my learned friend spent quite a lot of time on. Now, what does Borgas require? And I just want to deal with that. It says, paragraph 92, that you may not have to have a proved fact. I'll come back to that. But what you do have to do is explore and investigate. When you're assessing the weight to attach to an allegation, you need to investigate and assess, we say, whether or not there is a response to that allegation, whether he's had an opportunity to put it. It's not a controversial proposition. You need to think about, when you're thinking about how much weight to attach to something that the Secretary of State says, you have to think about whether he's had a chance to have a response. I don't say you have to do an adjudication in every single case, but if you're going to rely on these allegations, and there's not many of them, and they're all pretty much, the main ones are all at the beginning of the process, at early 2021, what you do need to do, when you're going to rely on those to justify 2 years of segregation within the security estate, within the CSC, within the high security estate, is you do need to think about it then, or at least reduce the weight you're attaching to the allegation, because there hasn't been a response.
All the allegations.
Sorry?
Or you're saying the more, this is your submission, the more time passes, the less weight you attach to each
Say
allegation.
that too. I absolutely say that too, and you'll be struggling to find an allegation that's maintained into 2022.
Where is it in
Well, what about the bottling incident?
Oh well, I mean, yes, of course, but it is. I mean, that's a slightly different example. But it was if you are going to say,
You mean the threats, I'm going to take a life? That sort of thing.
Yes, but if you haven't tested that, if you haven't put that into an adjudication process or some other process, and let me go back to the example of the probation officer. If you say, as he says in the witness statement, it's not being challenged, that you are relying on this matter. I haven't been given an opportunity to test this matter because I've asked for the recording which you rely on, and you haven't given it to me. I might have stuff to say about it, but I can't until I've seen it. Then you can't attach the same weight to it. So you exclude it completely. It's in the witness evidence.
No, I'm sorry. I am entitled to say this is no part of the written appeal, no part of the grounds of appeal.
Well, I think
no
it
part
is.
of the grounds of challenge below.
I think what I'm saying is, when you are doing the reasons analysis, which is absolutely part of Ground 5, these are the things that need to be addressed. And it's also a line that is developed today. Do we see, when you go through these documents, and again I invite you to read all of them, do you see focused attention on these matters to see if the serious thing that is being done to this man can be and continue to be justified? Just in response to, just on Borgas, it's trite law, I probably don't need it, but just for the avoidance of doubt, can I just show you Oakley? Because this thing about reasons, and it's partly about procedural fairness and ensuring you have a right to response, but it's also about improving the quality of the decision making. And can I just show you paragraph 26 of Oakley? I'll just ask you to read that and then put a line. It'll all be unsurprising to you, but just can I remind you, it was a point I made about this yesterday, and that's a reasonably good articulation of it by Lord Justice Elias.
Reasonably good.
Sorry, an excellent analysis. When I say reasonably good, I mean in the current context. The now, can I just make this point? When I'm making these points about you need to think about the way that you attach to things, I was surprised to hear the amount of time that my learned friend spent on the allegation about the psychologist and having made an inappropriate either touching or movement towards the psychologist. We have not taken instructions again on this over lunch. I have no idea what to make of this allegation. It's not in any of the operative bits of any decision making. I did a keyword search on touch across the core bundle and supplementary bundle. There is one reference to this allegation having been made. It's 2018. You think it was an allegation that was investigated and the grounds for which shifted. I don't know whether it's relied on or not. It doesn't appear to be relied on until my learned friend's submissions. I can't deal with matters in that way. I can't get instructions and say whether that's a substantial matter worthy of reliance. And my client definitely can't. If those points are going to be made, he needs to be given the opportunity to challenge it. They need to be in the reasons. He needs to understand it. He can't, as with answer to Lady Justice May, force an adjudication on it. He can't even, in this context, I'll come back to this in a moment as well, have what's called an IEPS review. You know that he was an enhanced prisoner from about 3 months into his arrival at Belmarsh. This is a fact which sits rather uneasily with the overall thrust of my learned friend's submissions, which is he's a bad man who's manipulative and disruptive and difficult. He is an enhanced prisoner at all material times from about October, November 21 onwards. If he was doing bad things after that period, they would presumably take his enhanced status away, and he would have the opportunity to review that. Would be a sub-adjudication. It's all done on the papers. A sub-adjudication way of testing some of these allegations, but not even that happens here. In this context, can I also just show you De Silva, which my learned friend referred to? We said we've been So you've had to ask.
I'm not a great fan of pleading points, but it does seem to me to be a new point to be saying that the committee's decisions are hopelessly vitiated by the unfairness of having in mind an allegation never adjudicated upon, that Mr. Thakrar once touched a female probation officer or something or expert or something inappropriately. The only mention of that in the documentation was on the very narrow issue of whether he should be allowed to be in a room alone with a female member of staff, or that's all.
But if you're, indirectly then, what's going on? If you're going to engage in this sort of way, but one has to put allegations that are, if that is being if it's not being relied on,
It's not being relied on.
Well, that's fine. But it's an example of why it's important to focus on what are the reasons for the decision, what is the justification for it.
Well, it is indirectly being relied on, isn't it? Because
I think
it's
so,
being
yeah.
said he is failing to engage. He can't do a risk assessment because although he can engage to level 1 with a psychologist, the next level assessment needs to be in a room with the psychologist. And he can't be in a room with someone alone, so he's either in a room with somebody, a member of staff supervising, or he is with a grill between them because of this allegation. And when we ask why, we're told it's because of that allegation in the background. So indirectly, it does come in to the refusal to engage point that is being made.
Yes.
Of course, by Mr. Krasinski.
Yes, which is why I say, look, I don't know whether what I make of this or not. If this is, it's not in the reasons for the segregation. That's why you need proper focused attention, so we can actually work on what the actual grounds are. And you can't just throw mud. This is really important. And we are going to, we are going to look at the fact that, there's a January 23 allegation about him having shouted out of a window to other prisoners, fill in your Comp 8 or whatever it is, your complaints forms. Now, that is not, if that's seriously relied upon as a reason, then it's got to be very weak, because that's just telling other prisoners how to complain and etc. And they might be right to complain, and it's rather people fall in complaints forms than did anything else, particularly in the high security. But other than that, you've got these allegations that are right at the beginning in April and May 21. You've then got this allegation that he encouraged other prisoners in August 21, but you'll remember the point which comes in by reference to SB 350, which is expressed slightly differently. In some of the documentation, it suggests that he incited violence. In the other, he said, you should realise that this woman is a racist. Again, it is clarity, and I would say even if that was true, it wasn't capable of justifying this treatment. But at the moment, all I need is you need clarity in order to understand what exactly is being done. And in support of that, can I just flag the Silver case? And I just put this in, and we have slightly impermissibly, I hope you'll forgive the informality, I've asked my learned junior to highlight relevant passages,
Yeah.
but I just want, just in the interest of speed, but can I just show you paragraph 154, going through Pierce, which my learned friend has handed up, and you'll see at 154, which is paragraph
Hang on, are we
154.
going to De Silva or to Pierce?
Sorry?
Are we going to?
I'm not going to Pierce, I'm going to De Silva, which is the later one. And essentially what happens is, just so you have the full picture, and this is in the context of separation centres again, so there's almost certainly analogous context. You see the claimant's case there was that the Separation Centre Management Committee is not required to determine every contested factual allegation, but it is required, so far as it can, on the information which has been available to it, or which it was able to obtain, to explore the nature of that allegation and its surrounding circumstances in order to make such findings of fact as it can about either or both on probabilities. And then down to paragraph 161, which is applying parts of the Supreme Court judgments and Pierce to that. So that it's again, it's not judicialisation of the process, but it is saying you need to investigate this and do a bit of a process rather than just making passing references to things. I'm watching the clock. Can I just take this point next? When my learned friend was dealing with my grounds 4 and 5 and was talking about the principles of law he relied upon, he talked about you can assume that there is institutional memory from one month to the next and we don't have to repeat it. I have shown you the blank sections. You've now got the table that our teams were put together overnight. I invite you to go back to them. There are a number of the documents that are either, particularly in late 22, where the reason sections, the operative bits of the decision, are either blank or formulaic, as they say, suitably located at this time, suitably located, whatever that means. To say that that's permissible each time, and to say that it's permissible as the second stage decision in relation to segregation as opposed to placement in the CSC, reduces the Borgas requirement for meaningfulness, substance, and increasingly compelling or detailed reasons, reduces that requirement to 0 if my learned friend's submission is correct. So that is why, and it's doing it in this very anxious context, which is CSC. Can't be right. You do actually have to think about it and show that you are thinking. I say the same thing in relation to the fact that, I've already touched on this, that there's no need for separate consideration of segregation. It's not enough when you need to direct the decision makers to think properly about what they are doing and the risks that they are running, amongst other things, to say suitably located when you know where he is enough. Again, that reduces the requirements, which have been held twice at Supreme Court level and in the Grand Chamber, to meaninglessness. More is required than less. Not saying what the outcome should be at this point. I'm simply saying you need to think about it. You properly apply your mind and be seen to be doing it. Back to the reasons for the case law on reasons and why it matters. Can I just, when we do go back to the decisions, can I just do a couple of examples? Because my learned friend did go through, and I think I've already referred to this, but my learned friend was going through saying, look at what he knows, look at what he knows. I'll give you a few more examples of that. If you look at page, he knows, therefore he's getting the reasons. These are reasons, these are not reasons. So if you look at, for example, page 237, I'm just going to ask you to do this exercise generally throughout this. So you've got the update section, the mental health team section, and the CSC psychology team. He's done his scores of false or nonsense against him. But they are things that are said there are A, not part of the reasons for the decision because they're not in the feedback section, not the CSCMC as a whole, considering that as a flying mind reaching a conclusion. But secondly, look at some of these. How does telling him and getting his comment on whether he is seen daily by the inpatient nurse for review, there are apparently no specific concerns about his mental health. How is that relevant to his ongoing segregation in any event? And you see similar things throughout these. You see similar things throughout this. A lot of it is comments that he makes on process, whether he was invited to things he didn't object to, factual matters about procedure that he doesn't accept. Again, what we need is, particularly around this time, if you get into later in 2022 in particular, what do you, CSCMC, say about it? At this stage, there hasn't been any recent allegation of threat. So say we're in mid-22, so you hasn't had anything like the probation officer or the take a life or whatever else that these things, the untested things, whatever you make of those, they're not here anymore. We can't say that you need segregation because it's the only way we can. It's the only way we can have you here for the county court proceedings in London County Court. Those are over. The only remaining thing is non-engagement. You need to look at what are the reasons for non-engagement, what's he saying about that, and whether it's justifiable over this increasing amount of time. And you don't get it.
Hang on, there is a bit more than that, though, isn't there? Because you're not contesting his location within the CSC estate, and we know that there are restricted number of places within that estate, and that those places, the people need to be moved around for other reasons within that estate. There are certain people who can't mix with others, and there are other things to be taken into account. It's the multifactorial.
And the small number of prisoners that are there, and if they've all been in a long time, they've fallen out with each other at some point.
Absolutely.
I see all of that.
And there's a history.
And there's a
taken
history,
into account as well.
because he's been attacked by them. And by the way, been attacked by them and not responded, and Dr. Crasiati has a point about that.
All right, but all of that are extra considerations that need to be taken into account when deciding on his progress through the CSC estate.
Agree, accept that, but they're not done. That's not in these decisions. Where you do see that, finally, right at the end of the process, in the movements paper.
Yes.
And that's the strongest to get. But he doesn't get that. That's the movements paper that's written and discussed. He's not. Those aren't part of the reasons to which he contributes. And that movement, I'll come back to it, but that movements paper also doesn't address the fact that he's been in a long time. There is material about impact. There is. We might be making it worse, etc. And the reason now, I can see that what you might do is go, all right. We see all of that. He's tricky. I can see this case. It's tricky. It has resource problems. We've got a limited number of people with whom he can associate. There's a limited number of places where he can go. All of those sorts of points.
What do you say to the proposition that in assessing grounds 4 and 5, you have to look at the totality of the evidence, the totality of the reports, the minutes, the feedback over the period to determine whether the breaches you allege have occurred?
Well, to the
You
extent
say that there has, insofar as there is a breach on any of the occasions, then your case is made out. How would you put it?
Yeah,
Or
yes.
somewhere between the two.
Well, I say that you have to examine conventional orthodox judicial review. You have to examine the decisions given by the decision maker and which are that you do need to look at that. Then I don't, you know, to the extent that there is a gap in that, I would say you know, some of that may be supplied by evidence elsewhere. But so if you're looking at the movements paper, it's not supplied to him. So when they talk about
I'm asking about the minutes and the reports. The minutes, reports.
yes,
It's for the basis of grounds 4 or 5, as I understand it. You've taken some documents which show
Yeah.
inadequate reasoning, you say?
Yeah.
But
they're
so
not-
it's the opposite. Do we take each individual one and say if there's one break, then your case is made out? One inadequate document? Or do we look at the totality to see whether over the period of time he was they did address their mind sufficiently and they gave adequate reasons? How would you put it?
the requirement is that you have to do it lawfully, which means intensively, at each stage. You can't just say, well, generally it's all right over the whole period. That is not the level of discipline that you need to do something this
But in reading each document,
Yeah.
do you read each document individually, or do you read it in the context of the previous
If-
documents?
If my case was my only interest in the quality of the reasons is because I want to be sure that you've confronted the reasons and thought about it, and it's a reason that I couldn't have said anything about, there's nothing I could have said in response, then maybe, and this is not what happens here, but then maybe you would be into the territory where you could rely on the minutes saying, all right, Mr. Armstrong, but the only bit that's not communicated to him is the bit that does show them thinking about something quite intelligently, and then it's difficult to see what he could have contributed to that. Maybe I would get, I'm not conceding this, but maybe I would get into that territory. But you're not here, because in the movements paper, I'll just take that as an example, he would have stuff to say about that, because it's talking about associations and where he can go and what his experiences are, and the obvious source of that material is him. So talk to him about it, and by the way, there's no justification for not doing so. Secondly, you're not dealing with the point that ongoing, nowhere do you see the fact that this might be just a terrible idea, which is you're just making it worse. You become intransigent. Talk about he's been intransigent, they've been intransigent. So there is an impasse on both sides, and we do say that the Secretary of State is under a greater obligation to move on this, move his camper van in the Cornish village faster than Mr. Thakrar is, because the Secretary of State is not subject to all the restraints and the mental health presentation and the rest of it that Mr. Thakrar is. But the reason why you want to ensure that they understand the impact and that they can't do it forever is so that then they do look at things like movement options. They are looking at that against a background that means they know they've got to do something about it. They can't just sit here forever, and you don't see it. You don't see it anywhere. So I say they're not good enough. Passing references to knowing where he is isn't good enough. All of those matters. I've dealt with enhanced. It's all very difficult to square with the fact that he's enhanced in the relevant periods.
Sorry, but that's the reason they're there.
Sorry?
That's the reason there is a CSCMC, because of the impact, recognised impact on anyone of being
Wow.
in the CMC estate
primary
and
reason.
segregated within that estate.
Primary reason, as you see from the documents themselves, is that the CSCMC is there to look at whether you're in Rule 46, not whether you're in the CSC at all, and which unit. That's what you see from the Mrs. Justice Ellenbogen decision, and that is where you do not see. I mean, what they've done in Rule 45 and the guidance that accompanies it is remind you every time that when you do this, you need to think separately about segregation because of its particular impact. And you don't have it here, and it is very worrying and should give, we say, the court real pause for thought about whether this is a working system.
Or is that an issue for us?
So I just say forensically that it is part of the background as to whether you're looking at the quality of the reason, and it is relevant to my ground left. But what you have here is we all know in judicial review that decision making is improved by having structured decision making and ensure that people jump through the hoops that they're talking about, particularly in complex decisions, thinking about the things they need to think about. But the fact that the CSC MC, particularly a national CSC MC, which is obviously concerned with where you are nationally in the high security state, is focused on whether you should be in the CSC at all or which CSC. And on the face of the document, that's what your attention as report writers and decision makers is addressed to, is a problem. And it's probably a contributing problem to the fact that you keep getting not either blank documents or suitably placed. Most of them are not in DCs. They need to be told that when you've got somebody in a DC or otherwise segregated, you need specific consideration, and they're not getting it. And they, you know, there's good reasons why, you know, and it would improve things, and it might produce something which we would all celebrate, which is some movement, and begin to move people on. And that's what they should do, and they're not. So that's what I say about my grounds 4 and 5. Can I just make some specific points on Article 8? I say it can't be justified. I say that, you know, it is at least something that raises an eyebrow. I don't put it much higher than that. That if you went on to Manchester immediately afterwards, after the end of the hearing, and everything was fine, and that's kind of slightly Secretary might want to explain why that couldn't have been done earlier. He's supported in some of that but there is a specific point here that this is where I say, because it's relevant from the non-vaccine case, is that it's also relevant that the reason he had at the time about not wanting to engage with psychologists when they were the discipline officer was a reasonable one. Dr. Crassiati supports him in that. He is doing something that is, he thinks, as the guardian of his own mental health, that he's right to do it, and that weighs differently in the balance.
Why?
But
it's a matter of law.
why? Because one of the things that Article 8 protects is your own bodily integrity in the views that you take in relation to your bodily integrity. And if he is saying, I'm not sure, you know, I may make my PTSD worse, I may make my responses as a result of triggering my PTSD worse, I'm in the position to know this, then it is a respect for his individual integrity to go, all right, you're the primary decision maker on that. Now, I know it's different to an anti-vaccine case, and I know that he's a prisoner and a high security prisoner at that, but it is at least of some weight. And even if it wasn't, even if there was a completely irrational reason for all this, it would still be something you couldn't justify forever. How much respect to give to the Secretary of State? I don't want to go back to this too much, but again, this is not macro socioeconomic, thinking about consequences of paying lots of money to lots of different people, pensions type case, nor is it a case where, you know, this is a shifting social standard where societal views and norms is changing and we should leave those things to Parliament. Nowhere near those things. It is an area, I say, where the court is more than usually experienced at being able to check what the Secretary of State is doing, because the court regularly sentences. It carries out sentences in relation to people who are at risk of serious harm, see what used to be IPPs and now extended sentences, and see what it does in relation to bail conditions and management risk in the community. This is not stuff that is out with the experience of the court. Equally, what the court does regularly is assess expertise and say, well, okay, you may be the expert. You come along, you're doing this now. Explain to me why you think it's still necessary, and then interrogate the reasons that are given. Why do you think it's still necessary? That's a process the court carries out all the time. My Lord Justice Bean was putting this to me yesterday about personal injury experts. Interrogate these decisions, look at the reasons that are being given for them, and see whether they are justifiable. But you don't have much in the way of reasons explaining why it is, because they're not addressing their mind to it, and then we're back into misbehaving and all the other those cases. Dr. Crassiati, I'm going to just do a bit more on this. Can I just say this? My learned friend takes his points about Dr. Crassiati and he attacks it in the way that leading counsel is capable of attacking it, and those attacks are not contained in any of the decision making. Say that the decision maker actually has decided to put Dr. Crassiati to one side because we don't like the letter of instruction. None of that is that's a clever point from Mr. Brzezinski, but it's not in the decision making.
It's a rather important point, isn't it, Mr. Armstrong?
It reduces the weight, it doesn't reduce it to zero. And the point is this, in particular because it doesn't impact on what we say are the core points upon which we rely on Dr. Crassiati. And, you know, she, consistent with other reports. Can I just whip through what I rely on Dr. Crassiati for? First, she points out that there is a significant view in support of PTSD, paragraph, page 59. Secondly, he has an understandable reason for restricting the for resisting the restrictions that were then in place, which is included having a discipline officer in the room while psychological assessments were being carried out. That was the position at the time she was advised. She hasn't dealt with what his position is now, but that's because she hasn't been, because we're only concerned with the time period up until 2023. She says he has good insight into his condition and what it means. That's an important thing, you've heard me refer to it several times. He does have significant insight into his own mental health presentation and risk. She says that she has tested him on that, and as you would expect an experienced psychologist, forensic psychologist to be able to do, she thinks his insight is pretty good. That is not disturbed by the letter of instruction. That is an assessment that she is used to carrying out. It's a familiar task for a forensic psychologist, and that she conducts it. You can make the criticism my learned friend does, that she gets it wrong that there were no verbal threats. I accept that can reduce some of the weight that is attached, but it doesn't go to the other matters we say. And what she does say there is he has been attacked by other prisoners and he has not responded with violence. And that is a point that says when you're doing risk assessment for somebody, that is a matter you're entitled to take into account, and you should take into account that he is managing his own risk in that way. She also says that the thing that is occasionally referred to in the documentation, that Mr. Thakrar is a pain in the neck because he keeps making all these complaints and claims, she says that is not a security or risk issue. That is what you want them to do. You want them to do it through lawful means, however annoying that may be. And I remind you and the court that he's often successful in this.
Why do you say that these points aren't undermined by the letter of instruction? The letter of instruction, I think you've accepted, gives a, well, how would you put it? What's your concession?
It's
about
not a CPR. It's not the kind of letter of instruction that you'd expect, for example, a joint expert's right. I accept all of that.
And,
that's,
and,
it's
and
partly
insofar as through the letter of instruction, I'm not accusing anybody of anything, but as a result of the letter of instruction, she makes errors in her report. In some at what point does one say, well, those errors undermine the whole of the evaluation? After all, that's the point of the very strict rules in the CPR, and for that matter, the family procedure rules about letters of instruction. And because expert opinion, as given other false instructions or erroneous instructions, won't be completely wrong, but the underlying value will be undermined by
of course,
that.
yes, of course. And
So-
it is.
What weight really attaches to it, do you think?
Well, it is that letter of instruction. It is far too informed by Mr. Thakrar, as I accept, Mr. Thakrar's own level of distrust and the advocacy that he wants to do on his own behalf. I accept all of that. That's
Well,
why
the reason
I
we have these rules about letters of instruction is because lots of things have gone wrong in
sure.
family cases and civil cases because of experts instructed individually on erroneous bases.
She has also set out her letter of instruction she was work hard to do. She's declared what she knows and she doesn't know, so
Yeah.
you're able to carry out
Yes.
this evaluative
But
exercise.
we're not. No one's attacking her integrity at all. You'd expect the letter of instruction to be
Let me go to the
exhibited,
core point.
and she doesn't answer she doesn't
Well,
answer the
exactly,
letter.
to her credit, she does the exercise that she's used to doing, and I remind you that this isn't a CPR exercise at all. This is an exercise of influencing the risk manager. It's not even before the parole board on this. But the point when Dr. Crassiati says, I've had a look at this guy. I know prisoners. I've been doing this for 30 years. I am watching the way he reacts to me, including in booking this room when I'm trying to have the consultation, and he was tricky and untrusting in circumstances where I actually think the Belmarsh staff would be quite helpful. She writes all of that down, but she says he is getting to and she says that is evidence of the security restrictions making him worse, making him more ruminative, making him more suspicious, making his perception of injustice much higher, making him harder to deal with and engage with in the way that you're trying to avoid, but you, the prison service, are making it work. Now, that, on the face of it, given what she is seeing, given the assessment that she's conducted, an absolutely correct assessment. But certainly, it's hard to see how that is undermined by the letter of instruction. If she was giving a marginal view or a surprising view, then it might be that the letter of instruction would be an explanation for why she'd gone in a surprising direction. But that's not this case. She is writing, saying this is consistent with his long-term presentation. Some of it's consistent with what others have written about him, and it's consistent with what we know happens in even short, definitely long-term segregation. So I say you can't put it to one side in the way that my learned friend says. I've made my points about movement options. I rely on my. It's not because I'm. Please don't take it. I'm abandoning it. I'm just running out of time, and I'm doing a couple of other things. Don't abandon Article 3. We haven't appealed on the substance of it. We have, however, said that you need to put the procedural breaches that we say are present into the assessment, and you need to do it with a proper understanding of the standard of proof. That's all I want to go back to. Can I just make this point of correction on Article 8? My learned friend says in response to, I think, the Justice Bean's question about this, what do you do about a wale? And he says, well, there is no longer a policy challenge. The policy challenge that we haven't appealed is a very discrete policy challenge, which was only, and you can go back to the underlying grounds, that was about the inclusion within the operating manual, about you can even do this to somebody who's just passive refuser, as just a passive refuser.
Well, that's not what it was confined to on the plea.
That's how we're arguing it. But that's how, absolutely, that was all our case was.
Let's not have heckling in the last.
Well, we can have a tit for tat over pleadings,
Yes.
but that's what that was about. So that doesn't take us anywhere. What we now have is the position which we've always had, which you compare Rule 35 to Rule 46. Rule 46 is less good for the reasons that I've said. They are in a comparable situation and within the ambit of convention rights. Ambit is not a high threshold, Article 3.8 and the rest of it, but you're definitely within the ambit. I'm running an Article 3 and 8 claim. I say I'm there on the substance, never mind whether I'm within the ambit. I'm definitely within the ambit. It is... the difference in treatment has never been explained. Nobody's ever put in a witness statement saying this is why it's done differently. We have thought about it, and this is why we want to do it differently. The only my learned friend says you didn't put this in your note. I don't want. I hope the court is not going to be significantly impressed by a submission that. There's not enough in a post-judgment submission about a wale to have it before the judge. The point about a wale on this ground is that it is a convenient summary of the substantive points that we had put. It's just an easy way of doing it, and we have absolutely put them. So those points were before the judge, and they are definitely before this court. Not least because the paragraphs that I took you through yesterday are in the skeleton argument, the permission skeleton. And the appeal skeleton. The only other point I want to refer to, because you are then looking.
Sorry, it's a convenient summary of the points under what?
The substantive points. The substantive points that we argue to get home, the pleaded points to get home on Article 14 are: you have two cohorts of prisoners, one who's under Rule 46 segregation and one who's under Rule 45 segregation. They are in materially similar circumstances. They both need that segregation to have attached to it procedural rights. Those procedural rights, the process rights that encourage proper focus, are better under Rule 45 than they are under Rule 46. Those things, because we are automatically in the Article 3 and 8 context, they are within the ambit of substantive convention rights, and the difference in treatment hasn't been justified. All of those points.
And is the law, which is certainly around over the last 20 years, about concentric circles and all that, applicable? But, if you're pointing to a difference in treatment on the basis of, say, gender or race or something else which triggers instinctive judicial levels of worry, then you apply a more exacting standard where it's a difference in effect of history.
I would have you mean
Suspect grounds.
Suspect grounds, yes.
Yes.
I mean, I understand. If they had a system that said you're going to have all these procedural entitlements for black people but not for white people, then I'd have an even stronger case.
Yes, of course you would.
But we're not in that territory. But I do say we're in pretty worrying territory. There isn't an expert. Why wouldn't you do this? Why wouldn't you say in relation to Rule 46, when they've lost so much already, we're going to have at least as much procedural protection to ensure you jump through the hoops here as you do in relation to Rule 45. And Mrs. Justice Ellenbogen clearly agrees with that because it's on a different analysis. It's an Article 8 analysis rather than this. And we just say she's right about that, and that's a convenient way into it. My final point on this, as I am now just after 3 o'clock,
Yes.
is my learned friend says, well, look at the DRAMs, it's a different system. There are other features to it, and therefore you can't compare, you're not comparing like with like. And he refers in particular to the DRAM meetings. You'll see those described in the evidence. I'm not going to go, I haven't got time to go through them now. That is a local process, it is an internal process. He doesn't contribute to it. It is not the decision maker on segregation. And remember that the problem that we are complaining about here, the difference in treatment here, is ensuring that you have a proper focus on the reasons for the segregation and that you're properly applying your mind to it. DRAMs don't give you that proper focus. They are not an answer. They don't save this process. Final point, before I sit down, Article 14 and 8 and 3 matter to Mr. Thakrar because if he could succeed on these grounds, even if he fails on anything else, on everything else. And the reason for that is if he is in a system which is insufficiently protected, then the unlawful treatment of which he complains is the failure to give him the protection. Even if in fact he got grounds, he's gone through a process that was less effective. And that is enough for him to succeed in relation to that. And that remedy would be worth having because it would say pretty much what Mr. Justice Ellenbogen does, but by a different route, saying you need to get better at this. You need to kind of prompt your decision makers to think more seriously about the things that we are inviting to think about. And I opened this case yesterday by saying, this is my high level point about this is if you're going to do this, you're going to do anything like this length of time, you need to take much more care than you are. And that is what we say has not happened. We can argue about which of the various causes of action it slots best into. That's my highline point, and that's where I say we succeed in a number of different ways.
We're concerned, as the judge was, with a specific period, 2021 to 2023. The question is whether any of the treatment during that period was in breach of Article 3 and so on. What the position might be now, not for decision in this case.
I agree, and I say 2 years makes it unlawful. But I would also just remember that my learned friend won't put a period of time on how long it's worth to keep going on it. He wouldn't. He was asked that specific question by Mrs. Justice McGowan and couldn't answer it. It wasn't, no time soon. And he said it again yesterday, I think, where he says that Ramirez Sanchez is 8.5 years. That would need to have very, very good grounds for this kind of treatment over that period of time.
I did notice that in Ramirez Sanchez, although it was a tick box exercise, one of the boxes was, does he still need consideration?
Yeah, well, exactly. You could do a much better form.
Yes.
Yeah.
Right.
Thank you very much, my lord.
Specifically asked that question.
Sorry, did
I think, well, I mean, Mr. Brzezinski was looking a bit doubtful, but I think
No,
there
no,
was a
no, I
box that
wasn't.
specifically addressed that question.
No, I don't make submissions.
Yeah.
Right.
Thank you very much.
Thank you all very much. You all covered a great deal of ground.
I'm grateful.
Including the customary volley of last minute previously uncited authorities. Thank you for all of those. Thank you for the careful preparation of the case. As you might have guessed, we're going to reserve judgment. We will, in due course, hand down a draft judgment as counsel know, but I still have to say it in every case. It's sent out in draft, not for re-argument, but only for correction of typos or any obvious factual errors, like a date wrong or a name wrong, something like that. I'm addressing this to the appellant as well as to counsel. It's not an opportunity to have. We don't want the draft judgment back with marginal annotations as to all the points we've got wrong. The other point is that the contents of the judgment are confidential to the parties, that is, Mr. Thakrar, his advisors, and those who need to know on the MOJ side until the formal promulgation of the judgment. Thank you all very much.
Thank you, my lady.
Court rise available.